Morning, what's your name?
Luana Glenn.
Luana Glenn, calling case 230-585-8701. People of the state of Michigan versus Luana Tish Glenn, defendants charged with count 1, weapons, firearm discharge in or at a building. Count 2, weapons, firearm possession by a felon. Count 3, assault with a dangerous weapon, felonious assault. Count 4, 5, and 6, weapons, felony, firearm. Count 7, domestic violence. The defendant is labeled as an habitual offender, second offense notice. Today is the date and time for a bond redetermination hearing.
Thanks, Judge. Good morning. Steve Vincent for the People, P71917.
Your Honor, Philip Reagan on behalf of Miss Glenn, who's appearing via Zoom from the Wayne County Jail.
What's Miss Glenn's bond?
$25,000 cash, Your Honor.
Okay, argument.
Judge, this is a domestic situation, Judge, between I believe couples that allegedly got out of hand, Judge, allegedly got way out of hand. My client's 53. I don't believe she has any assaultive history. She's not working, Judge. But allegedly, Judge, she and the complaining witness got into, a little tuckle-tickle. And, as Mr. Glenn was walking out, allegedly, my client took a shot, which, missed Mr. Glenn, wasn't trying to shoot at Mr. Glenn, but shot into the wall, And there was some physicality between the two. According to my client, she got roughed up a little bit, but she was in no way, shape, or form going to shoot Mr. Glenn. She could have shot Mr. Glenn, but she did not shoot Mr. Glenn, Judge. And I think, if anything, and I'm not saying this is what it was, but if anything, it could have been seen as a warning shot because I'm shooting away. But the problem with this whole situation, Judge, is that anytime we discharge a gun, whether we're, warning or doing, it's reckless. It's just reckless. That's not what guns are meant to do. We're not, it's not what we do. Now, I understand when things get heated and people get into arguments, I get that. But you're never, ever, ever supposed to shoot a gun, and I'm not saying that this is what happened per se, because I'm not going to be a lawyer. She's going to be able to provide a defense later on. But from the looks of it, it was more of a scare, and it was more reckless than anything, Judge. So I'm asking the court to consider reducing the bond to $25,000 personal. She does have a prior uttering and publishing, Judge, from 2006. That's her only conviction that I see. So I'm asking the court to consider no contact whatsoever, no contact, and a personal bond with GPS tele, Your Honor.
Mr. Prosecutor.
Thanks, Judge. I think it's ironic defense counsel used the phrase "get way out of hand" because that's exactly what happened. A gun in hand, the defendant ended up firing not at a wall. I mean, just reading the investigator's report, which we all have, it says that the defendant shot at the front door in the same direction that the complainant was leaving from. Now, Your Honor, I do agree with defense counsel. This was very reckless, and we do believe that the defendant poses a substantial danger. What wasn't in the investigator's report is the fact that there were complainant's kids in the house at the time of this shooting, Judge. The firing allegedly happened in his direction. I don't know if there's any clear danger than to discharge a weapon in the direction of an individual. Fortunately, nobody got hurt, but this could have gone a completely different way here. So with that being said, we do feel as though this defendant does pose a danger. We do feel as though, Judge, respectfully, that the cash bond is appropriate.
Judge, and brother counsel is right, Judge. It could have gone a different direction. Thank God it did not. There was one shot allegedly fired, wasn't multiple shots fired, as someone would really try to do if they were intentionally trying to hurt somebody. I think, Judge, if anything, I don't know about kids being in the house because I don't have any of that information. But Judge, I can say it was reckless. It was very reckless to do something like that, even out of anger. But I think that Ms. Glenn may be a threat to Mr. Glenn, you know, husband and wife. But if they're not together and they're apart from each other, they've been married, you know, some years, Judge, and you know, regardless of that, I'm asking the court to consider the reduction, Judge, to the personal with the tether, no contact whatsoever. I don't know if Mr. Glenn's going to show up at the exam or not, but regardless, right now, no contact, Judge.
Court haven't heard the arguments of counsel. Court finds a $25,000 cash bond as an unaffordable bond. In order to give an unaffordable bond, the court has to make a determination that there's either flight risk or danger to the community or an extra danger to the complaining witness. This is a case where, you know, I say it often, this is why there are just too many guns. One, the defendant has she's forfeited her right to possess a gun, having a felony. But either she didn't have a felony, doesn't matter. There wasn't a gun present, you know. They could have just had their argument and, you know, she's hitting him with a cane and he's hitting her with a broomstick. And this is all ridiculous and stupid. And they're in their 50s fighting with wooden objects. And it's just, but that would be a misdemeanor. Or that would be not in front of me with a $25,000 cash bond and possible killing someone or some innocent bystander outside or some kid, or I accidentally shot him in the back when I was just trying to scare him, you know, and I didn't mean to kill him. You know, this is why we need to stop all of this. Just stop it. We need to kind of learn how to have some better, you know, dispute resolution than canes and brooms and Rugers and, you know, AR-15s or whatever, you know, 22 caliber pistols, whatever. This needs to stop. With that all being said, bonds being reduced to $25,000 personal with a GPS tether, no contact, house arrest, can only leave for court and medical appointments only.
Thank you, Judge.
Thanks, Judge.